Hey everybody, welcome to another episode of Foreclosure Help 777, where we talk about everything foreclosure related. And this is my private Facebook group, which you can join us if you're in foreclosure or you have a situation where you need help from others. This is where we trade information and help each other out. So today we're going to talk about something a lot of people want to hear. And this is what a lot of people want to hear, is what a foreclosure win looks like. And let's start off with the Bible verse of the day first. The verse of the day is 1 Corinthians 15:57, and it says, "But thanks be to God who gives us the victory through our Lord Jesus Christ." So there's victory in Jesus, guys. And if you're in Him and He's in you, then no matter what you do, He's going to get you through it. And so this is a very important verse of the day. Okay, so let's talk about victory. Victory does not always look the way people expect. Sometimes victory is standing your ground. Sometimes it is exposing the truth, and sometimes it is gaining time to protect your family. Sometimes it is refusing to give up when the pressure becomes overwhelming. In foreclosure defense, victories come in many forms, and every step forward matters. Now, at the end of this video, we're going to show you some actual cases where the homeowner did won the house and everything. So don't stop watching this until the end, because the end is very interesting. Okay, so people assume a win means that the judge pounds the gavel and the homeowner instantly gets a free house. In reality, foreclosure wins come in different forms, and some of the biggest victories happen long before trial. So what does a foreclosure win look like? Okay, most homeowners think that foreclosure win means that the bank disappears forever, but in the real world, a foreclosure win can mean buying time, forcing accountability, getting leverage, saving equity, obtaining a modification, exposing defects, reaching a settlement, stopping an illegal sale, or even getting the case dismissed. That is winning. And there is a myth of the perfect win. Common misconceptions: I'll get a free house, one magic argument wins. If I find fraud, the case instantly ends. If the bank made one mistake, I automatically win. Real litigation is usually procedural and strategic. A win can mean time. Examples: stopping a sale, obtaining continuances, defeating a summary judgment, bankruptcy stay, discovery delays, mediation extensions. Time creates options. The longer you litigate, the better your odds are. So a win can mean leverage. Let's talk about this first. Examples: forcing meaningful settlement discussions, getting a loan modification, cash for keys agreements, good ones anyway, principal reduction, relocation assistance, repayment structure. The stronger your litigation posture becomes, the more leverage you create. A win can mean exposing defects. Examples: a broken chain of title, conflicting assignments, robo-signing, missing endorsements, standing issues, payment history discrepancies or inconsistencies, discovery evasions. Before discovery versus after discovery, you have more leverage after discovery, guys. A win can mean surviving. Examples: keeping kids in school, preventing immediate displacement, protecting elderly family members, avoiding homelessness, preserving credit longer, staying housed during litigation. Sometimes survival is the victory. A win can mean forcing the plaintiff to start over. Examples: dismissal without prejudice is common in judicial foreclosures. A non-suit or voluntary dismissal is another one. A defective process service is another one. Lack of standing at filing and defective notices. All these can get the plaintiff to start all over. And failure to comply with conditions precedent is another one. Even dismissals without prejudice can dramatically change leverage and timelines. Would a judge actually consider a winning homeowner? Judges respect homeowners who meet deadlines, stay organized, act professionally, focus on evidence, avoid internet myths, understand procedure, and follow court rules. And what hurts credibility are sovereign citizen arguments, emotional outbursts, filing nonsense motions, ignoring court local rules, not following court orders, late filings or late appearances, and fake legal theories that are rejected by most courts. Sometimes winning means knowing when to pivot. Examples: a strategic bankruptcy, a negotiated exit, selling your house before the auction, preserving your equity, avoiding deficiency exposure, relocation planning, non-suiting one case and refiling a new case. That's another pivot. A smart exit is sometimes a legal victory. Real examples of foreclosure wins. Now, here's some interesting things here. Examples: sale postponed 14 months, summary judgment denied, plaintiff non-suited case, homeowner obtained modification, foreclosure vacated. And here's one case you guys can look at here. Discovery exposed assignment issue. Here's Caliber Home Loans versus Sam Bertrand. And you can see the case information right here. You can actually look it up yourself. And the bank lost summary judgment because they failed to properly establish standing, they failed to prove transfer of the note, and they relied on hearsay. Their affiant contradicted himself, and they failed to prove RPA PL 1304 compliance, which is service, and the court ordered the case to proceed into discovery and trial. That is a substantial litigation victory for the homeowner. One of the most powerful lines in the decision where the court states, failure to make such prima facie showing requires denial of the motion, regardless of the sufficiency of the opposing papers. Okay, so here's another case that's a winner. To prevail in a forcible detainer action, and this is Texas, a plaintiff is not required to prove title, but is only required to show sufficient evidence of ownership to demonstrate superior right to immediate possession. If it becomes apparent that a genuine issue of material fact regarding title exists, the Justice Court does not have jurisdiction over the matter. In other words, this was Michelle versus Armstrong Capital Corp, and it's Texas. The bank was not able to evict them because they had an ongoing title dispute in a different court. And when that happens, the lower court has no jurisdiction. So that was a win for Mitchell. And then it says here more information about it. In Mitchell versus Armstrong Capital, the homeowner challenged whether the lower court even had jurisdiction to decide possession because genuine title issues existed. The appellate court recognized that when a forcible detainer action becomes intertwined with title disputes, the Justice Court may lack jurisdiction. So that's very important educational point for homeowners, because many people think the eviction court already ruled, so everything must be over. But Mitchell explains that possession issues and title issues are not always separable. Some foreclosure-related disputes exceed the limited jurisdiction of eviction courts, and homeowners sometimes win simply by forcing the case into the proper court where title questions can actually be litigated. Here's a key lesson. If genuine title disputes exist, a lower eviction court may lack jurisdiction, meaning that the plaintiff cannot simply shortcut complex ownership issues through a quick position proceeding. Sometimes the victory is forcing the case into the correct arena instead of allowing complicated ownership disputes to be rushed through a limited eviction court. Now the next one, which is another win, is Yavanna versus New Century Mortgage Corporation. What made Yavanna significant was that the Supreme Court of California recognized that a borrower may have standing to challenge a foreclosure based on a void assignment, even though the borrower was not a party to the assignment itself. This was huge because before Yavanna, banks often argued that the homeowner cannot challenge assignments because they are not parties to them. But Yavanna pushed back on that context, allegedly void transfers. The key distinction was a void assignment is legally ineffective from the beginning, and a voidable assignment is valid unless and until challenged by a party with authority. That distinction became central in foreclosure litigation. For your presentation, this fits beautifully. Yvonne versus New Century Mortgage. Again, you guys need to read this one. Okay, so the next case we're going to look at is Wells Fargo Bank versus William Carrington. He's been fighting since 2008, and we are at, 2026 now? So in a way, he's won because he's had it in court so long, but he also won an appeal. And for that, let's see. Yeah, he won his judgment on appeal. He got it reversed on appeal, and it went back to state court. He did lose in trial court, and he's appealing that. So, but he's still in his house, guys, even after this many years. So to me, that's a win. Next case is Rachel Tennyson. Lakeview Loan Servicing versus Rachel Tennyson. You can read the final judgment here by Sam Lindsay, the judge. Basically, she challenged jurisdiction. The case was dismissed without prejudice, as you can see right here. So now the bank has to start all over and try to file a new foreclosure. But she successfully got that one. So what happened? Plaintiff filed federal foreclosure-related action. That would be Lakeview Loan Servicing. Went after her in federal court because she has a HUD loan. Court questioned whether federal jurisdiction even existed. Extensive briefing was followed, and the federal court dismissed the case for lack of subject matter jurisdiction. So the key lesson here is sometimes a foreclosure win means forcing the court to confront whether the case belongs there at all. And honestly, this pairs beautifully with the Mitchell one. Now there's other ones here. These are actual wins where the actual homeowner got the house free and clear. Just go over them real quick here. You want to look these up if you're in New York, because most of them are. Well, I shouldn't say that because there's one out of Utah here. Article 13 LLC versus Central Mortgage Company. The outcome, the plaintiff's motion for reconsideration was granted. Summary judgment granted in favor of plaintiff based on retroactive application of the FAPA, Foreclosure Abuse Prevention Act. So that the lien was extinguished. And then here's one, Daniels versus Deutsche Bank in 2021, and this is out of Utah. The outcome, the homeowners won. The statute of limitations has expired, and the court held that seeking a loan modification does not restart the clock, and the debt was discharged in bankruptcy. The bank's right to foreclosure was extinguished. Okay, so that's a win. And then there's this one, which is the state of New York. Price versus U.S. Bank, 2024. Outcome, homeowner successfully secured mortgage discharge based on expiration of the statute of limitations, which is FAPA. And then there's, let's see, there's another one. It says it's Price versus Nation Star Mortgage. Okay, summary judgment, cancel mortgage, won because lender failed to accelerate the debt, which in 6-year statute of limitations. And then there's this one, the 1042 Realty versus PHH Mortgage. Summary judgment was granted for plaintiff. Mortgage was canceled and discharged. The court ruled that revocation of acceleration is only effective if it occurs before the statute of limitations expired, and it didn't. And then there's this one here, Kristen Lee Davis, which is a bankruptcy court in Florida. And the key holding, the court finds that the debtor timely submitted the notice of cancellation and canceled the loan. Bank of America's mortgage is void and no force in effect, and the debtor is not obligated on the loan. So that was another win for the homeowner. Okay, and so winning in foreclosure court is not always dramatic. Sometimes it looks like another month in your home or year. Sometimes it looks like forcing the truth into the record. Sometimes it looks like exposing defects that were never supposed to be questioned. Sometimes it looks like leverage. Sometimes it looks like dignity. Sometimes it looks like protecting your family while the battle continues. And sometimes it looks like rebuilding your life from a position of strength instead of fear. A foreclosure win is not about getting everything. Sometimes it's about refusing to give up everything. So what do all these things have in common? Persistence matters. Procedure matters. Deadlines matter. Evidence matters. Jurisdiction matters. Standing matters. Discovery matters. And homeowners have more rights than they often are told. Most foreclosure cases are not won with one magic argument. They are won through pressure, persistence, preparation, and procedure. Okay, guys, that does it for today's presentation. I hope that this was informative for a lot of y'all and gives y'all hope. Keep fighting the big fight, and if you need any help, you can always send me an email to foreclosurehelp777@gmail.com. You can leave comments below. And thank you for subscribing, and everyone have a blessed day.